It is my privilege to take you through this Knowledge Leadership Forum lecture by Honorable Justice Sri D. Bharata Chakravarti. I kindly request you all to rise for the invocation song.
मैत्रीं भजत अखिलहृजेत्री मैत्रीं भजत अखिलहृजेत्री मैत्रीं भजत अखिलहृजेत्री आत्मवदेव परानपि पश्यत आत्मवदेव परानपि पश्यत युद्धं त्यजत स्पर्धां त्यजत युद्धं त्यजत स्पर्धां त्यजत त्यजत परेष्वक्रममाक्रमणम् त्यजत परेष्वक्रममाक्रमणम् मैत्रीं भजत अखिलहृजेत्री मैत्रीं भजत अखिलहृजेत्री जननी पृथिवी कामदुघाते जननी पृथिवी कामदुघाते जनको देवः सकल दयालुः जनको देवः सकल दयालुः दाम्यत दत्त दयध्वं जनता दाम्यत दत्त दयध्वं जनता श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां श्रेयो भूयात् सकल जनानां
Thank you. May I now invite Dr. S. Vaidya Subramaniam, Vice Chancellor, Shastra Deemed University, to welcome the gathering.
Distinguished and Honorable Justice Sri D. Bharata Chakravarti, the Judge of the Madras High Court, Dean Professor Srikantan, faculty colleagues and my student friends, it gives me great pleasure to welcome Justice Chakravarti to the Shastra Law School campus this morning to deliver the Knowledge Leadership Forum lecture on a topic which is not only contemporary in the professional ecosystem, but also I think it's a topic that is very close to the heart of the speaker himself. In fact, when we organized a workshop in Chennai in association with the Asian Development Bank Institute on mediation for corporate contracts to avoid conflicts in corporate contracts. And we had a very seasoned expert in the field of mediation, Madam Mrs. Uma Ramanathan, as the workshop coordinator for that event. And at the end of the workshop, when I had approached her seeking help in identifying somebody from the bench to deliver the certificates at the end of the workshop for the participants, there was no hesitation from her when she suggested that Justice Bharata Chakravarti will be the right person to actually come for the valedictory session, which he did. And that was 4 years back in Chennai in a very small setup. And I still remember the passion with which he delivered the lecture. And at that point of time, I also wanted to invite him to the campus, because that's the time that we also set up a very small initiative through the support of Tata Sons when we wanted to set up an establishment that can use AI for ADR. And this 4-year relationship that I developed with him has now also resulted in his physical presence on campus. As the judge of the Madras High Court, we are extremely happy to have him address on a topic that is very, very contemporary. So please put your hands together and welcome Justice Bharata Chakravarti. So he started his career as a practicing advocate in the early 90s. And then was the public prosecutor for both the state and the Union Territory of Puducherry before he was elevated as the judge of the Madras High Court. On one side, he had a practice that covered different domains, and now sitting in the bench as a judge of the Madras High Court, I also see the multiple facets of law that he is handling sitting in the bench. But one thing that has not changed at all is his passion, if I can call in that way, his passion for his first love in the subject of law, which is mediation. And, a person who is an expert in mediation, which is very, very one significant tool in ADR, he has really contributed a lot in developing the contours of ADR in general and mediation in specific, because this is something that is very, very essential given the fact that we are burdened with a lot of a judicial backlog, and there are a variety of reasons for that. And on top of it, there is also this sweeping monster called the AI, the artificial intelligence, which is actually significantly changing the way in which different professions are actually undergoing a drastic reimagination and repurposing of the very basic tenets of the profession. And law is no exception at all. And that is why when we talk about AI in law, and specifically AI in ADR, there is definitely a lot to learn for students of law through a person who has experienced both in different ways because of his professional experience. And also that we had, for the benefit of the Honorable Judge, we had Sir Richard Susskind delivering a lecture some 5 years back when he delivered the Nani Palkiwala Memorial Lecture under the aegis of the AI and ADR chair. He was talking about 5 years back on how AI is going to actually transform the legal ecosystem. And in his latest book, Tomorrow's Lawyers, also he said, law is a profession where there is no retirement. Okay, so today's lawyer, it's unlikely that you're going to retire. So today's lawyer have to be tomorrow's lawyers. And if you have to be tomorrow's lawyers, then you have to definitely engage with AI. And we cannot have a person more qualified or better than Mr. Bharata Chakravarti to deliver a lecture on this topic, AI and ADR, for the simple reason that, I also believe that there are two conflicting points that make the adoption of AI challenging, especially in the legal profession. One is the tacit knowledge that is required in the dispensation of justice, because it's knowledge driven, and so it has to definitely not compromise on the tacit knowledge that is required. And the cost of error is also very, very important. So we cannot afford to have erroneous judgments escalating costs of administration of justice. So when both of these meet, it is very, very difficult to say that AI is going to replace everything. But we can always look at certain sweet spots where the tacit knowledge requirement is very low, the cost of error is also very low. And it is at these sweet spots that AI can smoothly integrate and make sure that they actually elevate and add value to the current transaction that happens between the various stakeholders of the judicial ecosystem. So it is with this background, I am extremely happy once again to welcome Justice Bharata Chakravarti to deliver this extraordinary Knowledge Leadership Forum lecture on AI and ADR. Thank you very much.
Thank you, sir. It is my pleasure to call upon Professor Sri Srikantan, Dean in Charge, School of Law, to present a memento to Honorable Justice Sri D. Bharata Chakravarti. Thank you, sir. I take immense pleasure to say a few sentences in His Lordship's honor. Honorable Justice Sri D. Bharata Chakravarti graduated in law from Dr. Ambedkar Government Law College, Puducherry, and was a general practitioner conducting litigations at the Madras High Court, tribunals, and subordinate courts at Chennai. His Lordship practiced along with colleagues Mr. T. Sai Krishnan and Justice G. K. Ilantirayan as the law firm Sai, Bharat and Ilan, and served as a public prosecutor for the Union Territory of Puducherry at the Madras High Court from 2017 till the date of his elevation. His Lordship is an accredited mediator with the Tamil Nadu Mediation and Conciliation Center, having mediated around 400 referrals, and is a trainer in mediation, having trained mediators and referral judges in several states in India. His Lordship has been the Joint Secretary and Coordinator of the Madras High Court Mediation Center and is an arbitrator empaneled in the Madras High Court Arbitration Center. His Lordship has authored Seek Mediation, an awareness booklet, and translated the Mediation Manual of India in Tamil for the Tamil Nadu Mediation Center and has authored the chapter on community mediation in the book Mediation Policy and Practice. His Lordship ran a mobile app, Lift Law in Fingertips, a bilingual free legal educational app, and is a trained volunteer in the Madras High Court Gender Sensitization and Internal Compliance Committee. His Lordship was elevated and appointed as the judge in the Madras High Court on October 28, 2021. It is a matter of immense pride that His Lordship has consented to deliver the keynote address on AI in ADR in today's event. May I now invite His Lordship to address the gathering.
Morning, everyone. Informal as the hope that's fine with the Vice Chancellor. Thank you for inviting me over here. I'm so happy to be amongst all of you. That's the first driving force, to be among my young friends. So we'll go straight into the topic. I was called upon to talk about AI in ADR, alternative dispute resolution. Okay. Now, if you have any questions which you want to ask at the outset, you are free to go. Or we will have a question and answer session in the end. Sometimes there will be this question up front in your mind to be asked at the outset. If anything like that, you can ask. Otherwise, I'll start. I'll start? Okay. All right. Now, artificial intelligence uses all kinds of mathematic tools, fast electronic chips, and it works on a mind-blogging speed. Okay. Here I am a human being, that to a 55-year-old man. Will go slow into the topic only. So forgive me if I am delving too much into the basics before we go into the crux of the topic. I would like to go that way. Okay. First and foremost, there is a dispute or a conflict. If a conflict or a dispute arises, there are two ways to end that. These are the two popular methods. And you can see from the diagram, there is some overlapping also. Okay. So a dispute in a formal court, delivers the verdict and decides the case. That method we call it as adjudication, right? In an adjudication, okay. So the formal court or the tribunal decides the matter in accordance with a very formal procedure, and you have the other remedies of appeal, revision, up to the special leave petitions. You normally have the appeal remedies, and then the conflict or the dispute ends by a binding verdict. That is the first system, adjudication, which was the mainstream system. But then there is the other method, which we call it as resolution. By the word, what is the difference which we feel between adjudication and resolution? In a resolution, it is based more on informal methods and more consensus and consent. You adjudicate a dispute, but then you resolve a dispute. You adjudicate is the mainstream, but then there is alternative way, that is resolution. You rely on a formal procedure, make it transparent. Justice not only be done, but seem to be done. That core method in which you are going by the regular formal procedure. You create an informal procedure. You create an atmosphere of trust. You work with the party, collaborate with parties, and then try to resolve the dispute. That is the adjudicating system, and this we call it as the ADR, Alternative Dispute Resolution System. You see, there is an area which overlaps also. For example, arbitration is partly consensual. Both of you should have an agreement, but then it ends the dispute by a adjudicated award only. Okay? That is why Afghan's case called arbitration is an alternative method, but it is an adjudicatory method of dispute resolution. You're going to the IBC. What happens there? It is an adjudicatory mechanism, but then a resolution professional is appointed. It is a resolutionary method of adjudication. Okay? Therefore, resolution and adjudication were initially two different compartments, but then there is some overlapping also. Okay? Arbitration is an ADR mechanism, but is partly adjudicatory. But in the sense we call it resolution because you have the initial consent, you have the very limited scope for appeal. Similarly, IBC may be an adjudicatory, form part of the tribunal or the court only adjudicating. No consent is required. A creditor goes and petitions, a financial creditor goes and petitions. But then the resolution professional is appointed, and to an extent, though it ends by an adjudication, consensus and consent is also involved. There, that is an adjudication by a resolutionary process. Here in arbitration, it is a resolution by an adjudicatory process. You understand? That is a little overlapping area. Therefore, now we know. Next. Now we know what, that is why we call it as, apart from the regular adjudicatory process, the rest we call it as ADR. We all know what is ADR. ADR is the alternative mechanism. By using different formal and informal methods, the dispute is sought to be resolved. The emphasis is on the word resolution rather than adjudication. Okay? The primary forms of ADR, negotiation, we all know. First, the dispute arises, we try to negotiate directly, direct negotiation. You all heard about the Harvard project on negotiation. William Urey's work on getting players, how to get the best out of negotiation. Now you have negotiation competitions happening in law schools. We are getting trained to negotiate. We have trains. negotiation is the first. Then negotiation fails. All right, we'll have a third party neutral called mediator. In the presence of mediator, we try to negotiate. Mediation is another process. Negotiation was the age-old process where the parties communicate directly without the help of any third party. But then when the third party called mediator assists, and when it becomes a very, very scientifically, trained and a particular with a known set of rules, if the process goes, that is called mediation. Mediation is also a traditional concept as well as a modern tool which we now use. Okay, see the oldest evidence we have in our Tamil Nadu is relating to the epic called Villi Bharatam in Tamil. The Mahabharata is translated in Tamil called, it is known as Villi Bharatam. The entire Mahabharatam is written in the form of poetry. You know how it happened. Two very learned brothers had a dispute. They had lots of properties. So they reside in the Theni district. In those days, the king who ruled, people go to the king only for verdict if there is a dispute. There is a partition suit which they brought it before the king, the brothers. But then the king was a mediator. He never adjudicated the issue. He tried to resolve the issue. He asked both the brothers to stay in his palace. He arranged food, everything. You are all very learned. I am told that you are masters in Mahabharatam. You do one thing. I'll give my verdict on your dispute. You stay in my palace, read the Mahabharatam for me once or twice. They read, and then they came before the king after 6 or 7 days. King asked what? They said, yes, we read. The king was taken aback, and he asked them to again read it. Then again they went back to their respective places, and then they realized the purpose for which the king asked them to read. And the legend goes that after 15 or 20 days, they came together and told the king that all the dispute between. And then the king said, now that you have resolved the dispute, you translate the Mahabharata into Tamil for my people here. And that is how both the brothers Bharatam, there is also carvings to the effect. And this is the evidence we have because we were practicing mediation, the truest sense from the olden days. See, people say that the traditional panchayat should not be equated to mediation. I agree. But then the panchayat is not the one which is portrayed in the movies, people sitting in a common place in a village and try to force down the throat some decision, go on caste lines. That is not the one which you are speaking. There is n number of mediations which were taking place in our village homes. Small hut is divided into two brothers. The family and two bulls. How poor family, 3 vessels. There are a neighbor came. The traditional in the roadside Pillayar temple. Always see after the puja is gone, everybody is gone. One lady is standing there with him, conversing with him, sharing something with him. No, he is resolving the family dispute. I have written in that book itself how a traditional village barber, you tend to share more when somebody keeps their hands on their head, and then see, father is proposing that we will jointly sell this land. It's all right if this much of price comes, register office, and so many disputes being resolved by the barber also in the village. The hair who does the thing. This is the traditional system, and now we have put into the modern practice. See, world over, for example, the US history, they say in 1996 people got agitated over the regular system. And then Roscoe Pound's first lecture in 1896 and 1906 in the American Bar Association was an eye-opener for everyone. You are only doing your own thing. You are not caring about what people want. It went to an extent that there was voices that justice without judges, law without lawyers was the voice which was raised, because the society got so fed up with for everything you went into the procedure and thing only. That is why the lecture of Roscoe Pound in the American Bar Association resonated, and a series of laws were enacted periodically. Finally, in the 1980s only, the alternative dispute resolution law was, federal law came into effect, where it was made mandatory that they should go into the alternate disputes before coming to the court. And then in the 90s, they are now able to resolve 90% of their disputes through alternative methods, and 10% only goes to the trial. For a developed country like US, it started in the 1896, and to achieve 90%, they took 100 years. Now the Indian thing is that we luckily, I am told that Senior Advocate Vaidyanathan was here last week. See how fortunate you are all. He is the one who assisted the court as amicus in the Salem Bar Association case. He, along with Honorable Justice K.V. Vishwanathan, both of them were the amicus who assisted the court. First the CPC amendment came. The Law Commission flagged the issue that we have to go by way of ADR also. And then the CPAC amendment came. Then the Salem Bar Association challenged it, and then it wanted to withdraw only, but the Supreme Court said no, wait, we will have to implement these ADR methods. The Supreme Court appointed a committee. The committee gave its recommendations as to how we can implement the ADR method. Like Senior Advocate Vaidyanathan was the one who had assisted the court himself in that as amicus, and along with Justice K.V. Vishwanathan. And then the committee of experts gave its rule, and then the Supreme Court framed its modeled rules in the second Salem Bar Association case. And then, even before the formal announcement of the Government of India, or without waiting for anything, Honorable Justice Markandeya Kajju was the Chief Justice of Madras. He started the first official mediation center. And thereafter only the MCPC was constituted in a year or two. And then from the Madras High Court, we went to the Delhi High Court, it came to Bangalore, Gujarat, everywhere it is happening. But then it started officially, and we are only 20 years officially. And then see how much of talking we are doing about the mediation. That is how the mediation history. Then arbitration, we all know that, in the first Geneva Protocol, and then Geneva, see, merchants go everywhere. There are disputes have to be resolved. So they needed a mechanism by which they can resolve the dispute quickly. If they are not able to, negotiate and find out, they wanted a binding verdict. All that they needed is a quick resolution, time-bound resolution, which can be enforced across jurisdictions. That is how arbitration came into effect. And then after the initial bilateral arrangements between many countries, slowly it started, and the Geneva Protocol, and then the Geneva Convention in the 1920s and 30s. Convention. India is a treaty, and then the Citral model law. So origin developed country. 1782 is the Bengal resolution, or the Bengal Charter, you can see, where there will be a clause. If the parties are at dispute, they can appoint an arbitrator, and the courts will only interfere if the arbitrator is corrupt or partial. No other ground the courts will not interfere. Exactly as the law stands today, it was there. And then the Madras Charter in 1810. 1810 was the Madras Charter, by which arbitration was introduced, and then slowly it developed. Then the Indian Arbitration Act 1899 came, and thereafter the Arbitration Act 1940, and then based upon the model unicitral law, the Arbitration and Conciliation Act 1996, which now governs the arbitration. You all have learned something about the law of arbitration, when the court will interfere, what is public policy, when the court can interfere, when it should not, what is the international arbitration, what is the domestic arbitration, what is an institutional arbitration, what is an ad hoc arbitration, and how to enforce the awards. This is what the ADR of arbitration as it stands today. Lok Adalat is our unique system which we have developed. Lok Adalat is for the masses. We have millions of cases pending. Lok Adalat is our unique system which caters to, especially to the motor accident cases. Cases like motor accident, cases arising out of Negotiable Instruments Act, which doesn't need much of spending of time. But if there is a formula, if there is a fixed formula, how much loss they have sustained, whether it is an injury case or a fatal case. If it is a fatal case, what is the age of the person? To what is the so because it was a straitjacket formula, it was easy for people to quickly negotiate in Lok Adalat, and every month the national Lok Adalat being conducted. Thousands and 10,000, 20,000 cases get disposed of. That is unique to our country. It is volume is more, and then the reach is more. The common people get benefited out of it. Even other type of cases also settle it. There are other forms of, like many countries, like we also have judicial settlement. Now, initially there was a artificial, distinction which is maintained between conciliation and mediation also. Now with the Mediation Act, it is officially done. It is one and the same. You call it conciliation or you call it mediation, it is one and the same. The legal principles are one and the same. Everything is one and the same. Now, the early neutral evaluation, expert evaluation, all the other forms of ADRs which are prevalent in many countries. And then finally, the ODR, Online Dispute Resolution System. Online dispute resolution system is also part of ADR. Okay, it is a type or a hybrid form of ADR. It is completely online or it hybrid also. All right. So when we talk about online dispute resolution, with the advent of after the computational abilities, we moved on to the internet era. Internet era started, and then this platform started emerging, which gave rise to the ODR. Okay, primarily online dispute resolution can be divided into two types. One is tech-enabled human intervention. I was doing the same thing in a physical form. Now I am doing it online with the enablement of technology. The second one is completely technological and artificial intelligence oriented. The human element is totally dispensed with, and then online dispute resolution is conducted by the technology itself. This is broadly the two types of ODR. What are the prevalent forms from the beginning? From the beginning, what are the forms which are prevalent in ODR methods? We can broadly classify in three forms. First, we call it as blind bidding resolution methods, or blind bidding mediations it is called. That is, a chatbot or a virtual assistant helps you in all, such as a consumer good being returned and get a receipt, which there is a calculation of interest which we make. These small clients, what given a drop down menu, enter their problem, they enter their thing, and then they enter the amount for which they are going to settle on, and then it makes a calculation and it is settled. Large amount of claims from these kind of platforms such as Amazon, etc., these e-market platforms. You can go to the website called e-Jagriti by the consumer department. You can see the variety of consumer goods related disputes. So it is found to be very, very effective for these minor disputes, which is mostly AI driven only. The virtual assistants or the chatbots take the inputs with their inputs based call, it makes an output and it decides for the company, and then it gives them an offer. Most of them accept the offer and settle. The money is getting credited back to their bank account, or if it is to be a replacement of the good, it is being replaced. So this is this is called as blind bidding dispute resolution process or blind bidding mediation. There is no actual negotiation between two sides. Okay, this is something I take a rough call. All right, I'll settle it for 5,000. Okay. Then if that call is accepted or a counter offer is made, and then the issue gets settled. It's called the blind bidding matter. The second one is the narrative mediation or a narrative dispute resolution system. Okay. In a narrative system, what happens is that I go to a technological platform, mostly in the form of an email. Here I have a little more story to tell. I enter all my facts. In a narrative mediation, this intermediary, it may be a human, it may be a chatbot or the AI element also. What it does is that it reframes the whole issue, communicates to the other side. Here there is really an other side, who is the other party against whom you are communicating. Then give an offer. Then this intermediary may be a human mediator or a chatbot, considers the offer. It already has a guess what the other person will do. It communicates after paraphrasing the whole thing. After, in a manner, it will be accepted to the other side, and then the offer is communicated. This is called narrative mediation or narrative ODR process, where the entire to and fro is being taken. There may be human intervention, there may not be human intervention. There can be two types of models. The third type is the face-to-face model. What we are doing online, offline, it is internet enabled. The only good thing about is that we are there in our respective places and we are able to do. Maybe it is mediation, maybe it's a mediation. So any type of ADR can be done face to face, but in the presence of a third element called the computer system network or the artificial intelligence system or whatever the platform. We always call it a third party and an important party because that makes a lot of difference in the dispute resolution process. See, the ADR methods came into effect because of the theory called contact theory. The first thing after conflict, what happens is that the contact cut or our physical proximity will not be there. You come this side, I'll go that side only. So that is the major thing. The primary plank of ADR was on the contact theory. Now that is being challenged on account of this face-to-face or the third-party element called computer. For that only, as an alternative, is proposed as a communication theory. All right, you and I sitting together in a room, unspoken, so many things will continue upon seeing your face, upon an eye contact. By a body language, I can communicate so many things. All right, now you communicate everything. I'll give you the common serene atmosphere. In an atmosphere of trust called the online platform. So contact theory is being replaced by communication theory. The at the table concept is replaced by around the table. Okay, there is nothing called a table here. One person sits here, one person in another country, the lawyer can sit in another place, and the mediator can sit in another, or the arbitrator can sit in another country, and then it can happen. So at the table has become around the table, and then the physical proximity gives way to the thing called empathy. Okay, what you have to understand, tools, artificial tools, it has to be built with a lot of empathy. How and whether it is possible is the question. So ODR, when we say, therefore, a dispute, adjudication, and then alternative is resolution. Resolution only we call ADR. ADR, we have these methods. And there can be any number of new methods also. There is no end for the human brain. I was talking to your vice chancellor about the indigenous methods people will have. There are so many methods by which people used to resolve the problems. It is not that we alone. I always used to say, in fact, when we are part of the discussions came for enacting the Mediation Act, I was in the camp which opposed the legislation also. According to me, they are putting the genie inside the bottle. That is what I would say. You can't get that I am the lawyer, I am the judge, I only know to mediate. Example of the traditional haircutter or the the temple gurukul who can also do mediation. The neighboring elder sister will do the mediation. That is what is the concept according to me. The point is the when we say those types, and then so therefore that is the ADR method, and then ODR is part of it. And now we go, yes, next. Now from now on, it is something which I have to learn from you. I use AI only for two things. One, to do research. Second, for my open code dictations and transcriptions. Now, these are the two things which I have used, not much. Whereas as youngsters, you will be using in a larger sphere also. So with that caveat, though I know something about the use of AI, I am a very limited user so far. So with that caveat, see, normally a lecture should be given by the persons who practice more rather than speaking. Anyway, I'll try to justify from here on. So we all know what artificial intelligence is. Artificial intelligence systems are programmed in such a manner, they use the mathematical tools, try to learn or create a pattern from the existing data or statistics, and then apply it and then perform the task, which is akin to human intelligence. That's what they are saying. Though they don't equate, in the manner as would a human being would do, they do. That is also, they classify into like the traditional, the intelligent, then the super intelligent one. Like they say, where they are programmed to do a particular task. That is the first, the traditional AI methods. Second is now what we are using, the generative AI, which itself can create contents, it can write, it can understand the natural language of the people, it can converse by itself, it can give ideas, it can generate content, be it writing, be it pictures, be it videos, everything it can do. Then the future, they given different names like agentic AI, or like a human being, it will do everything. Maybe it will have its own, it can even become a villain. That's what they are saying. So that we don't know what the future holds store. So that is the types we are saying. Now going into how it can be put into use, let us talk about what are the problems and what are the drawbacks. First and foremost, the usual first thing which they say is that it's going to replace all the human beings. And then what are we going to do? If AI is going to do all the work, and as human beings, what are we going to do? Already it is resulting in cognitive atrophy or this thing. We are not able to think and read two sentences on our own. We are so used to asking Google or the AI assistants. So that is the first and foremost thing. General in nature, not particularly with reference to adoption of AI to ADR. That's a general problem which we all have to ask. That is more on a ethical question, on a moral question for we human beings. What is our existence? Why should we employ AI? Should we employ AI or not? Is a large question, which is that is then. The second one, it relates, we all know that, relates to hallucination, data hygiene, data protection, and data privacy. Today, incidentally, we are having our lecture. Yesterday was the one newspaper. All see that the Data Protection Act has been notified yesterday, as of now. The data privacy, the data hygiene, and the data protection are the questions. AI uses our data to train itself. Without it exists. But then every company promises that we are not using your data for training our AI. Then from where did you get, from where the hell you are getting? That is the second common thing. Those are all the general in nature. The particular drawbacks, which I expect in the field of AI is that to do mediation or to resolve dispute, conflict resolution is not an ordinary thing according to me. It involves critical thinking and emotional intelligence, more of a critical intelligence. A basic drawback which the Pandits say is that AI works on mathematical formula, on the Bayes theorem or the game theory. Then from the existing data, it either predicts or creates something for you. Therefore, it may lack intelligence or the critical thinking or the mediation is all about creative mind only. You create new options. New option is generated. It is not what may not suit for the both of us in another problem. What suits both of them will not suit the other two persons. Maybe the same set of facts only. The same 5,000 rupees he has borrowed, he has not repaid. What solution I am giving to one person may not suit for another. One person may give a rebate on interest and accept only for the principal. For the other person, with the principal, everything 9,000 rupees is given. For the third case, it happened our mediation center only, no money at all. He said that in the temple, the first right should come to me. You will not contest hereafter. That was the solution between the both of them. Absolutely, he gave this thing for the repayment of the money. Pro note went into the dustbin only. Therefore, that is what we are saying. Then if you are going to use AI, when dealing with a money dispute, it is not going to think of temple. Human, that is what they are saying, the emotional intelligence. If you are going to repeat from the same patterns, if it is going to learn from the same patterns, of course, with new input, one case settled on temple, it will also consider the option in the next case. That's another thing. That's another thing. But end of the day, that limitation is found. Recently, for our newsletter, we asked the art college students to draw a picture. I've been writing stories on mediation. Okay, narrated a story. I also asked him to draw a picture of mediation taking place. Fellow, he did not this thing. He used that nowadays any number of AI tool is there. Now you go to an artist also, he is going to use an AI tool only. Then the moment he picture, I found out that it is by a AI product only. You know what? He has given the description. That was between two sisters. A sister who was gone and settled in the US 30 years ago, coming in a modern attire and attending the mediation. And another sister who is residing in Chennai, and therefore this fellow has given all the description. So it has nicely given one sister sitting in sari, another sister in a western. But where it showed itself, it showed with a bunch of flowers. I have never in conflict coming from, come so much of flowers on their head. No, never happens. So it got the input. See, that is where the difference between the human and AI. That settle things, that is what they call it as the drawbacks. Okay, so it got the input that it is a traditional lady from Chennai. All right, sari, give jasmine flowers. That's all. But I have been in mediation center. They come. Not that I am ruling out, but normally 99% people in conflict, they don't have the mood to do all that. That is another thing. But if you actually observe any mediation center also, you don't see many of the women folk coming there having flowers on their head. No. But the AI did it. That is how I found out that it's an AI drawn image. See, this is the drawback which they are thinking about. Drawbacks. All right. Drawbacks aside, now we'll go to the next. How it can be used. How AI can be problem solver itself, because long ago, I happened to read the work of Professor John Galtung. He's a Norwegian professor. He says resolving conflict is also science. According to, he calls it conflictology. He divides the conflict, human conflict. He starts by saying contradiction and incompatibility. Then he moves ego, alter ego, and the other person. Then he moves further. He is irreality, empirical reality, actual reality. Then he divides players, persons involved. I have read twice or thrice. It is for the maths professors. He is completely math. According to him, resolving conflicts is nothing but a set of mathematical principles. And credits to him, 50 long he has compared the entire science on conflict with game theory, which is popularly used by all these algorithms and the AI tools. He is comparing the conflict resolution method with the game theory, and he says it is very much possible. It is all mathematics only. Your ego, your behavior, your expectations, your facial expressions, your emotions, everything can be mathematically calculated. His theory. Then if it is theoretically possible, it should be practically possible also. Somebody is carrying it out. He did not predict that AI will, when he produced, when this science he developed, he did not predict that tomorrow AI will come. The second thing is also what they are saying is the good, that's what I am saying. About the use of AI is that we always ask the parties, to think about options. I will never play the devil's advocate or the reality thing at the outset. No, not only after 20 or 30 hours of mediation, if it is going to be in this, to think about what best can happen then. The property, there are three options open to me. I'm seeing this is mine, and that is my position. My position in court is that's mine. Please decide me in my favor. That is my position. I will get an interest under 1.5 lakhs every month and be happy for the rest of my life. The second thought is that I will develop it into flats. I'll sell 2 flats. I'll keep 2 for me also. Third is that I will develop a good independent house with a little lawn, everything. Now the 3 options are there. But what the problem is, we have a fallacy called the sum total fallacy. I can only do 1 out of the 3. But in the human mind, all the 3 sums and it weighs. That is the major problem in decision making in ADR processes for the human mind. That is the major problem. Fallacy. If you have more than 1 options, you can weigh, you can always have, that is what ADR is all about, to have more options, to have more than 1 way of treating, to have more than 1 way of resolving the dispute. But, you have the sum total fallacy. As human beings, all the things we stack together only. See, I can only sell or I can build a house. But the good feeling of both ways in my mind, and I am not giving ground, I am not coming up with any settlement. That is where what people say is that use of these tools, being a go-to tool, will help you in objectively analyzing your own case. Help of parties, in a way, it can overcome these human biases. Another thing is the bias of the AI they are alleging. That is another field. We are not going into that. But how AI can be better in the field of ADR is that first, they are equating conflict, resolution itself as a science, and it can be divided into pieces by mathematical principles, and then puzzle can be put in place also. That is one theory that they are saying. The second thing is that some of the human problems can be, overcome by usage of AI. That is why it makes a candidate tomorrow. AI itself, see, that is another policy which we are debating, whether it is going to assist the human being or it's going to replace the human being. That is for all of us as the society to take a call. Tomorrow, what's in store tomorrow, we don't know. The point is that it is capable of being a mediator or arbitrator by itself is the possibility, at least the possibility. And in that process, as we see, there may be ABC drawbacks and there are also advantages. Advantages all seems to equally weigh. Therefore, as it is only as a policy maker, how we are going to do this. See, this is the picture. Normally, I am saying I am leaving out the Lok Adalat and the other forms. In the modern commercial world, this is how things are happening. So there is a dispute. Now you can negotiate, end in resolution. If the negotiation, you can directly go to mediation also, or after negotiation fails, you normally attempt mediation and then ends up in a resolution. And then if the mediation fails also, you can still go to arbitration and then you can resolve the dispute. Now, AI can be at every stage. That is what I analysis of the dispute. The party, before going into it, there can be AI tools to analyze, to have a reality check. Am I on the right path or not? To that extent, tools are there and it can be used. And secondly, in the negotiation, as I said, Bhatna, what is my best alternative? Today, I have a plot. Okay? What is my best alternative? That is what they are saying. Instead of these ordinary tools, the Pandits say that AI tools inside mediation. What is happening in mediation? Whether the tools can be developed for those compartmentalized activities. So what are my option generation is one of the important in mediation. So can there be an AI tool for generating more options? It can, in a moment, it can read the past experiences throughout the world and it can give you hundreds of options. It is for the human to take a call thereafter. That is one thing. Second thing is that in a mediation, these tools can be developed. What they are saying is when you are going on online mediation, it's very, very difficult for the mediator to, take note of this body language and all. See, body language plays a great importance when it comes to mediation. You go for any mediation training, the emphasis that is given to body language and the emotions, you will understand. It is much more than in the other thing. Even to make a what they call it a sentiment, take the property, but then she's entire body language throughout the mediation process. How was she looking? How was he participating? He was an introvert or an extrovert? He was expressing himself or no? Those analysis tools have also come. So that is where those little tools they are saying in mediation. And again in arbitration, from the claim drafting to the counter, communicating, evidence recording, transcription, from the award dictation. So these things can be done. And in arbitration, there are so many processes, so many mathematical things which is involved. For example, you take all these constructions contract, they have the time delay impact, which has a lot of mathematical calculation. Now, I bring all my gains, everything here for that project. You don't give me the place for 10 days. What is the impact? How much is the calculation? All mathematical only. There are factors in which it is work. These are the with particular mentioning to the facts of the case. An AI tool can give the impact, what is the amount, what is the compensation, whether there is time delay impacted or not. These kind of tools can be developed in an arbitration. And finally, even at the stage of resolution, to have a check, okay, which is whether it is a New York Convention driven country, whether my award is enforceable or not, in what manner I can realize the award, whether all the clauses are strictly enforced in terms of the dispute. So many things the AI tool. See, for example, today you want to serve a summons on any person in abroad. You go to the Ministry of External Affairs, then only you'll know the difference. There are MLAT countries, mutual legal assistance countries. There are countries which do not have that assistance. There is separate procedure for which you have to go in which this MLAT countries. There is another set of procedure for the other countries. So these kind of, even after resolution, post resolution. So it at every stage. Now, what I'm saying is that not only the summarization, automation, workflow automation can be done, summarization can be done. For example, the Lok Adalat. You have 10 million cases throughout India. You can have an AI tool to pick up where there is no problem. The insurance company is not disputing liability, but disputing only the quantum. This is the price. This is the percentage of liability as claimed by the petitioner. The disability as claimed by the petitioner. This can be it can give you in no moment, with a mind-blogging speed, the classification. How much 10,000 cases if you have to, take and classify, how much time which is taken. So for the alternative dispute resolution system, Lok Adalat, you can have a great AI tool. That is what now I was sharing with the student and also the thing. I was told that Shastra is in the process of developing some AI tools also. I gave 2 ideas to them. Can I share it here also? Yes, the first thing which I told them is that in the court processes, you go to the lowest court, whoever is in that committee, students are working, kindly listen with care. See, 20% of this ordinary traditional litigation are only boundary disputes. The other person built a compound wall in my land, 2 feet he has encroached upon. When plowing the land, he came 2 feet inside also. The live fence, the tree is actually in my land only. I will not say anything until the tree grows bigger. And then after 20 years, claim that the tree is mine. That's how this kind of is. When you go to the trial court, initially, even when I was practicing, I thought when it was pending, advocate commissioners, courts resolved by locating where it is, whether it is approach to the opposite person's land. That is the problem. To think that all right seems to be of enterprise, or all these fellows are lazy only. That used to be my all incompetent fellows, I thought when I was in practice. But after I became a judge and I came into the administration only, when I start working with that munsifs or the subjects, they say, sir, really it is not. We are asking the advocate commissioner. That advocate is also a good advocate only. But the commissioner report is not. I call the commissioner and say, commissioner says, sir, yes, I gave the notice once, but then that one party had some difficulty. He went to Sabrimala or some bereavement in the family. That got cancelled. Thereafter, it is not, we could not go. Then I go to the surveyor and ask him, sir, one firqa, one surveyor only is the rule. But now, invariably, most of the surveyors are in charge of 2-3 firqas only. And one day, Jamaat, I have to go to the collector office. One day in a week, I have to go to the Tahsildar's office. The third day, updation of records, and I have only 2 days. Then the fourth day, when I ask him, he says that I can give the date to the regular Pata and the other persons, and only one day I can spare for these court cases. Then if they cancel my appointment this Friday, I will give them only after 3 months. Now then I said, there is a satellite image. There is a Nilamagal scheme. You can superimpose the satellite images on the Nilamagal scheme, find out from your table itself whether actually this compound wall is in your property or the next man's property. I say, that's what I said. You develop a nice advocate commissioner tool in Shastra, we will use it in, see, because you are the persons who deal in conflict, and then you have your counterparts working in the maths department or in the computer science department. Collaborate, build a tool, and that will go miles. That's what the other thing I shared was that a majority of, in the Indian context, no Western world will say 50% of our disputes is on from the villages is on account of where to locate the burial ground, where the cremation shed should be, where the bus stop should locate, where the school should be there, where the ration shop should be there. Nobody will tell you. This is a unique problem for our country. I said you have a set of rules. A school should be in a dry place, not on a water body, and it should be accessible. Ration shop should be, for example, the recent problem where the politics is going on around the location of direct purchase centers. The paddy is the moisture is not going. Then where it should be located? In every village, the president wants the place where he should command this thing only. No, that's not the place. Where it is higher in altitude and at the same time nearer to for the farmers to bring. Where if some rain comes also, there will not be waterlogging. That is the place to locate a direct purchase center. An AI tool can do wonders. These are the sources of conflicts. These are the sources of conflict which resonate in courts as civil cases, as civil suits, as petitions. I said you try a AI tool on these locational advantages. That was off topic. Sorry to go through that. So coming back to the topic, now therefore, when coming to the use of AI, finally what I'm saying is that so long for now, whether we are going to employ AI on its own or not is left to the future. But for now, the one line which they are saying is that we should not use AI to work for us. We should use AI to work with us. So long your human element and supervision is there, we can tap the best of the potentials of the AI. At the same time, overcome all the drawbacks. So for now, the best solution should be that along with me, my AI is there. It is not that I will sleep, let the AI work, and I will only check the output. For in the ADR process, output is nothing. It is the process which is sacrosanct. It is not how many cases I settle as a mediator matters to me. No. It is observing people, being there with them when they cried, being there with them when they laughed, being there with them when they saw, and when they started. As a human being, I alone can observe. That is the core value of a mediator. That is the core value of the arbitrator, to be with the people, the process which is more important. Now, if you are output oriented, you can have the AI work for you. Okay? But ADR is process oriented. You can only work with AI. I assume yourself having 4 hands, that's all. 2 hands are yours, another 2 hands are that of the AI. And you should not sleep when the AI is working. I'm saying metaphorically. That is, AI will take care of everything. Already it has summarized, therefore I'll use it blindly. No. Always have the human soup. For now, I am saying we don't know what future has in store for us. So I conclude by putting it this way, that from the dispute analysis up to resolution at every stage, in ever so many ways, that is what mediation itself or the ADR process itself is all about creativity. There is no bounds for human mind. We are always creative only. Every time you can come up with a new kind of process also. New things can happen. That they say will happen only with your own creativity and critical thinking. You think for yourself, and to aid that, you use the other two hands, and not to replace and not to put your cognitive thinking to atrophy or to put it into rest. Always walk together with the AI. Have it hand in hand, and we can do wonders is what appears as of today. Thank you for listening. I think I overshot my time. And then any questions? You be there only. Relax yourself. You can sit and talk also. Or all right. Yes.
First of all, good afternoon, sir. Thank you for.
She's reminding me that I overshot my time. You started with good morning and we are ending with.
Thank you for your
We don't-
precious time in addressing SASTRA students, sir. As AI has become common in mediation and arbitration area systems, what will be what do you believe in will be the safeguards to ensure transparency and accountability in AI assisted systems, sir?
See, already there is a huge debate on this new data protection bill, where it is good and where it has missed. As law students, it will be a raging topic from today on. What we have to take care is that protection of our data, and then the right to privacy as proclaimed by the Honorable Supreme Court of India in Puttaswamy's judgment. These are the things which we have to take care. And the other part of it is that check, for example, in a blind bidding medium, if the algorithms are programmed in such a way to absorb yourself in and then to accept what the system dictates. So therefore, inherent biases, that is what they are saying, the other things which we have to keep checking on. So what they are saying is that is what the recent principles that European Union AI Act also says, started. Respect fundamental rights of people. There are 4 principles which they have said. You can Google and find out. Respect fundamental principles of people, then alleviate all the biases, then transparency. What is the algorithm that is used in the AI, what is the programming that is used, you should be transparent, and then finally the data privacy and the thing. These are the 4 principles that European Union Act is a very, they say that it model to adopt also. Hope see, for now we don't have an law governing the thing. In our Information Technology Act, at best I think section 11, when you are tracing to the originator, the only word I think 11B or 11C, it will say even the content created by the software also, it will be traced to the originator. To that extent, only one sentence is there in our Information Technology Act. We have to come up with suitable legislation governing the AI also within the 4 contours. And they say that the European Union legislation is a good model to follow. And then OECD, they have got guidelines and regulations. And the third one is the UNICITRAL has also given regulations for ODR alone. The trade and this thing related disputes, when it is done on ODR model, it has given the broad guidelines. And nowadays, even in the court system, the Kerala High Court has come with guidelines on how to use the AI system. Tomorrow, a national model will also come. So as we rightly say, like the things are that the data privacy and the 4 principles which they say: respect people fundamental rights, respect their data, then transparency, whether you are going to use my thing or not. If what is the structure on which this AI is built on. These are the things which have to be made mandatory. Hope legislation will come, which will make it will make it imperative, respective develop to declare all this. For now, it is only ethics that they put in place. They announce it publicly that this is what the model which my AI tool is using. This is what the perils are, and this is what the advantages are. So we have to develop a set of ethical principles also. Thank you. Hope I answered your question.
Yes, sir. Thank you, sir.
All right. Yes.
Lordship, how does the judiciary assesses the authenticity and reliability of online mediation and arbitration proceedings, especially regarding the identity verification and digital evidence?
Identity verification
and digital evidence.
Digital
evidence.
See, though I said it in a lighter way, there is way to go, miles to cover. Actually, we in the judiciary especially, that is the difference between the internet natives and the oldies. We at the helm of affairs, I wonder whether we even know what is happening. That is one thing. The first thing is to acknowledge that we don't know what we don't know. Okay? We are unconsciously incompetent is the first thing which we have to acknowledge. What the judiciary should do is that we don't even know what we don't know, that we have to acknowledge is the first step. And then try to move to the second step towards the usage and identifying the issues to that stage, number 2. And then that is what the government is trying to do by this Data Protection Act. And then the usage of Puttasame's judgment, all that will come into frame. The basic legal framework is there. The basic legal framework is there. Even in the absence of any legislation, if you, the right to privacy law or, the Information Technology Act and the other structure is there. Even under common law, we can redress these issues. The only thing is that the lack of, awareness and knowledge, which is preventing us. And the best method is to first create an awareness only. Hope I answered your question. Traditionally, India is trying to have a national language policy. And, there has been a much this thing. Now with the advent of AI, this is going to, you can come to Chennai. You can see the Russian engineers walking with their phones. Language is nothing for them. They talk in Russian and then show it to you. It shows you in English. And then they easily converse. You can see the Chinese engineers doing that very efficient. Now, with the advent of AI tools, especially the natural language processing tools and the translation tools, it is better advantages for a multilingual country. I don't have to lose my identity as a particular language speaking people, or my language need not give way to her language. Now, I will say that the single most benefit of this AI is going to be that only. I can speak my own language and you can, reply in your own language, and there is a medium for us to, make us understand. And with the potential of the AI increasing day by day, it will only help in the cause of diversity of languages and, not steamrolling by one language or the other. It need not be. I think every language can enrich itself with the advantage of the AI tool and especially this natural language processing tool. Even for Tamil, the Mysore, what is that? The Language Research Institute. Now they have put in place almost all the words, and then now the computer also understands everything. Like English, now the Tamil options is also giving. You can see many of courts, like youngsters have now become magistrates there. They conduct most of their proceedings paperless only. Now, that's what on the other day I showcased. See, simple case of hurt. The neighbor, I hit a neighbor. There was an injury. 323 criminal case. The doctor who treated student, he has given the wound certificate and this thing. Now, he is now working as a surgeon in Hyderabad. Okay? Traditional system. In the traditional system, this for the doctor from the Hyderabad to come here and give evidence. It will take after 2 years or 3 years, because after all that poor fellow should find time and to come travel. Now it not only takes virtual, you can see if you dictate in Tamil, there is not even a mistake. Then only we realized, all right, the problem is with our language and not with the tool. When we want a good stenography tool, everything in English, it is not understanding. We are saying it is not understanding. The problem is with our pronunciation and the thing. Do the same thing in Tamil. It doesn't make even a single mistake, because our Tamil is very good and the machine understands. You can see these transcriptions happening. I can demonstrate. I have that video also with me. Transcriptions happening seamlessly. And more Tamil we can use. That's not a problem. That's how now the Supreme Court has said. that all the judgments of important judgment of the respective courts be translated in the native languages also. So more and more use of the other languages is on the way. Like one day, as Bharatiyar dreamed, என்றைக்கு வழக்கறிஞர்கள் தங்கள் நாவில் தமிழ் அன்னையை குடியேற்றுகிறார்களோ அன்றைக்கு தான் தமிழ் அன்னை உயிரோடு இந்த நாட்டில் இருக்கிறார்னு சொன்னார் பாரதியார். அப்போ that day will come also. That day will come also. Conflict resolution in the language known to the people only, language which they understood only. Traditionally, the Englishmen, they wanted to use Latin and Greek because the people should not understand. We are using English because the people is not understanding. Everybody is using the same thing only. That is what you read the ordinary one sentence in the sale deed. And whereas so and so now, whether the common man is able to make out or not is the question. And even when they write in Tamil, Kaspa Nilatil Kanda so and so Patta, that also nobody will understand. Better in English, you can see how the. So therefore, there is a silent which works, that the common man. This is what you would have heard this popular joke. Hope most of you understand Tamil. If some of you don't understand, I'll explain it later. Now, ஸ்ரீபெரும்புதூர்ல ஒரு குருக்கள் இருந்தார். அவர் அவரோட அசிஸ்டன்ட், ஆர்டினரி இப்போ ஓஏன்னு வச்சுக்கோங்க, அவரோட அங்கே பெருக்கி துடைக்கிற ஒரு எம்ப்ளாயை கூப்பிட்டு, அடே குப்பா, நீ திருப்பெரும்புதூர் சென்று திருக்குடந்தையில் இருந்து வந்த திருமங்கை ஆழ்வார் திருமாலை தரிசிக்க செல்லுங்கால் திருக்குளத்தில் திருப்பாதம் தடுக்கி விழுந்து விட்டார் என்று கூறிவார். Okay, this is what he told him. Who was standing the other two persons. What? This is a very learned man. He is conversing in such a pious and rich language to an ordinary person. But then, that person who was there, he was working with him for 40 years. Therefore, he understood. Then, when the other person pointed out, then he became suspected. நான் சொன்னது உனக்கு புரிஞ்சுதா, நீ போய் சொல்லிடுவேன். சொல்லிடுறீங்க, நீங்க ஒன்றும் கவலைப்படாதீங்கன்னார். செகண்ட் டைம் ஆல்சோ ஹி ஆஸ்க்ட், ஏய் நான் என்ன சொன்ன புரிஞ்சுதா, என்ன சொல்லுன்னு. தென் ஹி செட், கும்பகோணத்தார் குட்டையில் விழுந்துட்டார். It should be as simple as that only in that language. Okay, this is how we use all the law jargons. As you are right, language is a very important tool. They want even for, see, when we go to Chhattisgarh, when we go to Madhya Pradesh, there are even, see, we speaking about Tamil, Telugu, Malayalam is another thing. Speaking about the persons who don't have a, not even letters so far, they need not lose their language for years merely because you are an advanced. Now with the AI tool, for every word can be recorded and the meaning can be, deciphered. And with this digital transformation, it would only be more useful for diversity is my only thing is that all of us taking it positively in that direction. Thank you. Yes.
Thank you so much for the insightful session, Your Lordship. My question is actually ranges with the concept of deepfake. Given that deepfake gives threats with regards to authenticity, trust, and confidentiality, does the Lordship think that India requires a specific legislation for deepfake with regards to ADR and the governance of other dispute resolution mechanisms?
No, not only with reference to ADR. As you say, deepfake is a major challenge. Even for the criminal courts. See, we are a country which is finding very hard and difficult to arrive at the truth only, especially given a tool to tell lies, okay, to create false images. We will be the first, because how the world uses is another thing. How we as Indians use is another thing. We are not ashamed, or we don't even think for a second to create these deep fakes and the other things. So in that kind of a society, yes, you are right. Therefore, at least what I am saying is, whether a legislation or not, more awareness and more tools to find out these deep fakes and to bring appropriate, it should be actionable, and there must be responsibility, and then more and more technological advancement in the field is necessary. Already many judges find, especially in matrimonial matters, several pictures are given, several emails are generated, Several videos are created, deep fakes already are in web only. And then they say that improve their technology so much that, you know, to hard to differentiate between the real one and the deep fake. See, we are a country where the Honda engineer, you know, when they produced a fake engine in the witness box, the Honda engineer identified the wrong one as their engine. So we are capable of even in the real world also. That is what I am saying. This is something. This is some virtual and AI alone. This is not something which is something to, because AI gives a tool. Now we are saying that is something related to our mindset. This is something related to our morality. This is something related to our ethics. That is what I always used to say. Even well before AI or other thing came, in the trial, there were two engines which were kept. The engineer who came from Japan identified only the spurious one as their engine. On that basis, the suit was dismissed. But on the same basis, High Court decreed the suit that you created such a spurious one and dubious one. So that is the mentality of I'm thinking that more on the, it is on the aram which you base thing. I don't think this deep fakes can be controlled by any legislation. It is more like people should be aware. We should not jump into conclusions next second without even, see, last week also, we were sitting, I am a part of the green bench. Okay, some advocate came and running. See that there was a video where the tiger came and lifted the watchman and it ran away. Many of you should have seen only. See, this is what is happening. And we should also, some person already filed a memo mentioning that matter. It was AI created video only. Thereafter we entered. Therefore, the first thing is that to be a little bit more relaxed and then not jump into conclusions. Second thing is to develop the tool and analyze. Third thing is to cross-check the fact. And fourth thing is that to what extent and what purposes we are going to live in that virtual world. That is what I always used to think. Virtual world, both for our food and our emotions, not fit for the thing. Love, affection, everything we show only in the real world and not in that gadget. Similarly, food and the other things. So, some kind of a ethical awareness which we have, inner awareness is what inner engineering has to be done more. And as you say, yes, there must be an actionable tool which should find out, it should cross the check whether it is a deep fake or an original one. And then if deep fake is created, how to find out. And then people have to be put into thoughts. And these are going to be the modern day crimes, and we have to be equipped to do that.
Thank you so much.
Yes. Can I ask one? Yeah, definitely. Thank you very much.
Thank you very much for the insightful lecture. So I have this question on behalf of the young students here. Actually, this profession, the career pathway for youngsters has a lot to do with an experience that they have to gather if they have to really make a difference in the bar or the bench. And this AI is something that is very new for the profession itself. In your experience, how have you assessed the rate at which AI is adopted by the so-called quote within quote experienced people in the bar and the bench? And secondly, what is the advice you have to the young students?
All right. The first is that how far we, the elders in the profession, and in those who are in the helm of the affairs, have absorbed the technology and the thing. See, one thing you have to give credit is that maybe it is COVID engineered. 2021, at least process have started. That is what happened in any ADR processes. It is pre-COVID, and in all the third world countries, it is COVID engineered only. But at least after seeing that, oh, I can do this, now we are trying to adopt. Though not in the pace which you youngsters expect us to do, but still we are in the process of adopting. It is very hard for a person at the age of 50, 55 to switch to the other mode, and to forget about this notebook and take the other notebook. It's very, very hard on account of the long years of usage. But you can see still many of them are embracing technology also. It will be a little, it's a process only. But then I see many of even the senior advocates who has put in 50 years at the bar also, now migrating and using liquid text for their arguments with ease. And human mind is such greatness is that after 100 days you forget your erstwhile system and you are so adopted to this system. What is that there is a concerted effort, and if they take that first step, they will all come inside is the question. Those of them who don't even want to take the first step is only remaining this thing. That is what I used to tell them. You believe me or not? Now, people born after 2000, we call them all you are internet natives only, we call them. So when the internet natives become the stakeholders, that is what I used to tell them. When the internet natives themselves are going to be the litigants, then they are going to be the lawyers. They are going to see your old typewriters and the bundles stacked around. They are going to turn around and walk away somewhere else. Therefore, unless you wipe off all that and put the computers in place, they are not going to walk in. Therefore, it is going to be the pressure which is exerted by the stakeholders, which is going to make those persons who are hesitating to take the next step also to take the next step. And eventually in 5 or 6 years, the usage of AI and all the tools will be in place is my prediction. The second question, which is says that about the being the first generation and how to plan your career is concerned. See, generally, what I used to say is that tomorrow is not like yesterday. So don't my advice, which will come from yesterday's experiences only, because every day new things happening. See, you know what? Currently, I am handling a Supreme Court project. See, traditionally in our legal system, there is a court, there is a higher court. The higher court always corrects the lower court or affirms. It will always finds fault or it will always affirms the judgment. First time in the history. Now I am sitting with every magistrate. We are collaborating and we are doing something, which is new. If you ask any advocate of my standing or any person, any profession from the bar, what? The High Court judge and magistrate are sitting together. What are you blabbering? That's what they will say. Today, to wipe off all the criminal cases, now power is given to me under 482 to quash the non-compoundable cases also. You all know Gyan Singh's judgment, where if it is ordinary 294B, 323, 324 heard cases, both of them compromise. But then offense is non-compoundable, power is only to the High Court. But then cases are there before the magistrate. Now what we are doing, I sit in my dais, the magistrate is sitting in her dais. We are in a composite manner, we are disposing you. Have you ever heard of? It is first time in the country. This we did it, therefore, tomorrow, I don't know what is in store. But one thing I'll say, that it is not that you should totally discard the yesterday's thing, but when it comes to the creativity and the critical thinking, be yourself. Don't ask advices from us, but ethical dilemma. When you are in an emotional dilemma, you come to us. That is where you should take. And then you must be a happy person to shine in the profession. You need not compare with any person. If somebody is running faster, you will eventually catch him in 15 years. And after 20 years, he will be lagging behind. Don't even worry. Time comes in different zones for different people. As so long as you are happy and passionate about what you are doing, no matter how disadvantageous background from you are or how advantageous background you are, definitely you can come up and you will your careers will also be good. Only thing is that if you are a little bit affluent, little bit second generation, you can go to your office at 9 o'clock. You must be the person who opens the office and sweeps the floor also. That 1 hour or 2 hours you must be in a position to put in. And you must be the person, even if you are a second generation, you must be the person to go to when it comes to any problem. You must be the person who must become the reliable. You may be in litigation practice, you may be in a non-litigation, whichever scenario you are working. Within month, that is what I used to say. There is a great proverb that is also very contextual in the context of ADR. There is a Tamil epic called Pazhamazhi Nanur. It says, Vennir Nerupatrum Perku. Okay? That is, see, assume that there is a traditional food and a pot of water boiling. What they say is that the firewood is also helping. The firewood, what it does is that it also gets that heat of 100 degrees centigrade, but what happens is that it also starts burning. The water in the pot, it also absorbs that same 100 degrees centigrade, but then when it boils and spills, what happens? It douses the fire. In the field of conflict resolution, you should always be the pot of water and not the firewood to burn. So long as you are ethically strong in whatever field, I am sure that Olipadaitha Kanninai va tomorrow will be yours. Thank you.
Thank you, Your Lordship. It was an extremely insightful and engaging lecture. Thank you. May I now invite Chiranjeevi M. Sai Nihant Reddy, fourth year law student, to deliver the vote of thanks.
Good afternoon to everyone present here. It is my honor and privilege to deliver the vote of thanks on behalf of SASTRA School of Law. First and foremost, I extend our deepest gratitude to Honorable Justice Shri D. Bharata Chakravarti for gracing us with his presence and delivering such an enlightening and forward-looking lecture on AI and ADR. Sir, your insights on how AI is transforming the dispute resolution landscape, enhancing efficiency, improving access to justice, and shaping future mediation and arbitration processes have truly broadened our understanding. Your reflections on maintaining fairness, transparency, and ethics while integrating AI into ADR were thought-provoking and highly relevant to all of us as future legal professionals. We are immensely grateful for the clarity with which you connected evolving technology with core legal principles and inspiring us to think beyond traditional frameworks, and also for providing us with an historical development of ADR mechanisms and online dispute resolution systems and various technologies used for solving these disputes. And your guidance today has given us a clearer vision of the skills and mindset we must cultivate to contribute meaningfully to the future of dispute resolution in India and legal profession as a whole. I would also like to express our sincere thanks to our VC, Dean in charge, the faculty members, and the civil management for making this event possible. Finally, heartfelt thanks to all of the students for your active participation and enthusiasm. Once again, thank you, Honorable Justice Shri D. Bharata Chakravarti, for your time, your wisdom, and your presence with us here. We are truly honored.
Thank you, Nihant. May I request all of you to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे